Welcome to the Legal Insights with Mixon, Carroll, and Frazier.
Welcome to Legal Insight with Mixon, Carroll, and Frazier. We're here with Attorney James Carroll of Mixon, Carroll, and Frazier in Columbia, Louisiana. James handles labor and employment matters and represents clients in state and federal civil litigation. For decades, he's worked on disputes that range from workplace conflicts to serious civil cases, giving him a clear view of how these cases actually unfold in Louisiana courts. I'm LeAnn Lyon, and today we are talking about what civil litigation actually looks like in Louisiana state and federal courts. Hello, James.
Hi, how are you?
Wonderful. It's so good to be here, and welcome. James, before we get into the mechanics of litigation, can you share a bit about your background and how you came to focus on state and federal civil litigation?
Well, sure. Born and raised in New Orleans, and had the privilege of going to Tulane Law School, and from there I went to New York City. I had the opportunity to work with Jackson Lewis, one of the nation's largest labor and employment firms representing employers, and that's sort of where I cut my teeth on employment law. I also had the privilege of doing some labor law, and at the time, a long time ago, those were two different or distinct things. They're still distinct today, but most attorneys now focus on the employment stuff. Employment law started at the federal level with Title VII of the 1964 Civil Rights Act, and each state then adopted its own version of Title VII, and Louisiana did so as well. After spending a number of years in New York, I went to Texas, then New Mexico, and now I'm back in Louisiana where I was born and my extended family live.
Beautiful. So, when a civil dispute turns into a lawsuit in Louisiana, what does the process really look like from filing to resolution?
Well, it's a little interesting when you're in Louisiana because we are from the French NapoLennic Code, all 49, well, for the 50 states, 49 of which follow the common law system or the English system, and we follow the French system. Napoleon wrote the code, and we still follow that code today. So we have a historical difference that we're pretty proud of. So the code dominates, and case law supplements, whereas in common law, usually the common law or case law dominates, and the statutes give guidance. We tend to be the opposite, but over the years that distinction has diminished, and right now, as we practice in either state or federal court, the differences are de minimis.
How does the experience of being in state court differ from federal court here in Louisiana?
Well, the biggest difference, I think, is time. Federal court has always been considered the rocket docket. It moves a lot faster. The courts are appointed for life by the president, confirmed by the Senate, and there's a lot more autonomy at the federal level for the federal courts. They tend to have their own way of doing things. State courts are much more laid back. They are more tied to election cycles and a little bit less formal. It can be very, very quick in state court, but generally speaking, we find state court to be a little bit more, I hate to say slow, but that's probably the correct word. It takes longer to resolve things in state court than it does federal court, but state court has a whole lot of legal issues that federal court never sees. So there's a lot more work in state court. Or a lot more variety. Federal court judges might disagree with me because they're very busy as well. But I would think the difference is the formality. Federal court is much more formal. State court is a little bit more relaxed.
What tends to change strategically when a case moves from state court to federal court?
Well, usually it gets removed from state court to federal court when you're dealing with diversity of citizenship or you're arguing strictly a purely federal claim. For example, my specialty is employment law. So if you bring a state court action for discrimination under the Louisiana employment discrimination law, but you also include an allegation of Title VII, which is the 1964 Civil Rights Act at the federal level, then the state case could be removed to the federal case under either diversity of citizenship or federal question. And when that happens, scheduling orders kick in, and it's a much tighter controlled environment that requires a lot more focus by legal counsel than state court does. And state court judges are just as competent and just as incredible as federal court judges are, but federal court judges are appointed for life and don't have to worry about elections, whereas state court judges do.
Do cases ever go the other direction from federal to state?
There are occasions when it does happen, but it is very rare and happens. In my 35 years, I've never had anything go from federal court to state court.
Well, in your experience, where do civil cases most often break down? Is it discovery, motions, trial preparation, or something else?
I like to think of them, I guess I can compare employment law to divorce law. Uh, if you're the plaintiff, you're accusing the employer of being unfair. You're accusing them of being unethical. You're accusing them of being racist or sexist or any of the different categories: race, color, national origin, sex, religion. So it becomes an emotional issue, much like divorce work in state court. Emotions run high. And that's where I think attorneys really come in and try to keep the clients, both the employer who's being accused and the employee who feels that they've been wronged, focused on the facts and not on the emotions. And I would have to say that it most falls apart or breaks apart if it's not going to get resolved before trial, after discovery's pretty much completed and the process of the motion practice, dispositive motions and or mediation take place. We get a lot of success in getting cases resolved, but that first couple of hours of mediation can be very emotional, very gut-wrenching for the plaintiff, or if it's an allegation of sex discrimination or sexual harassment against a supervisor, that supervisor's reputation is at issue, and they become very emotional and very hostile. So, depending on the issues that are being litigated, I think it really focuses on the degree of culpability, what the level of proof is, and whether or not the plaintiff can get their day in court either through mediation or actually being forced to go to trial.
Is mediation mandated in the state of Louisiana?
It is not. It's something that some judges have some very strong opinions about. Some judges think it's absolutely wonderful and push cases towards mediation. I have had a couple of judges who believe that it's inappropriate and should never be raised. But I have found that mediation is an excellent tool that allows if I'm representing the plaintiff, it allows the plaintiff to have a say and to speak directly to the mediator, directly to whomever they believe has wronged them on the other side of the table, and be heard. At that point, if the defendant is in a position to resolve the matter, it can be resolved. There's an old saying that mediation hurts both sides. The defendant has to give more than they want, and the plaintiff has to take less than they want. But if it hurts both sides and a resolution is reached, then it was probably a very successful mediation.
For businesses or individuals who have never been involved in litigation before, what usually surprises them once the process is underway?
Well, that's a very good question. I think and I do both defense and plaintiff. I do a lot of employment law, but I also do a lot of litigation having nothing to do with employment law: contracts, fender benders, death cases. I think the thing that surprises plaintiffs more than anything else is the amount of time it takes to get to a resolution of the claim. There's a lot of things that happen behind the scenes that they don't see, they don't understand, and it takes a long time to get their case to the point that they thought it should have been months, years earlier. And that I think is very frustrating for them. On the defense side, I think the thing that causes them the most heartache is the cost. It can get extremely expensive. For example, represented a financial institution in which there was a very large policy that covered the cost of the litigation, and if the case was resolved, then there's a policy of, and I'll just use a round number of say $2 million to cover the cost. Well, by the time we got to the point of resolving the case, the policy had eroded to less than $1 million. And so what the plaintiff was anticipating in a policy of insurance of $2 million was now significantly less than $1 million that was available to pay the claim. And of course, that created animosity for the defendant because they paid this premium all along thinking they were getting $2 million in coverage, and they got less than $1 million to pay the claim, but they'd been paying their attorneys from that policy over time. So from a defense perspective, I think it's the cost of litigation, and from the plaintiff's perspective, it's the time it takes to get to a resolution. Either way, money is an aspect of both sides.
In that case, you mentioned the cost for the defense. Is there a cost for the plaintiff up front?
There is, and usually that cost is an emotional cost. Let's say, for example, it's a sexual harassment claim where the employee has been either attacked or are treated to some kind of extreme activity. Then they have to relive that over and over. The traditional case is a woman who's been asked for sexual favors from a gentleman or a man. Then they had to live through that experience the first time. Then they had to go through it again when they explained it to the Equal Employment Opportunity Commission, if that's the way that they decided to go. They had to explain it to their attorney. They had to explain it again in the deposition process. They had to explain it a fourth time to the mediator. And if they're not able to resolve it at mediation, they had to explain it a fifth time to the jury or to the judge. And by that time, I think the emotional toll is so extensive that they're emotioned out. And the PTSD that comes from that can not only be the initial event, but every time they had to revisit it through the process. From the defendant's perspective, if you're the person that's being accused, you've had to go through the same thing. So that's the emotional toll. That's the emotional expense. The plaintiff's cost is not as significant as it is for the defendant, because if the plaintiff loses, most of these cases are on a contingency fee basis. And so the plaintiff doesn't have to put any money out of pocket unless the court determines that it is a frivolous claim, in which case the court could award the defendant's attorney's fees to be paid by the plaintiff. That's very rare. I've never had that happen in 35 years. It's always been threatened, but it's never happened. But it's a possibility, and I have read cases where it has happened. And so that could be a very expensive result if you ended up losing the case and the court found it was a frivolous or unwarranted claim. Of course, that's my job to prevent you from bringing an unwarranted or frivolous claim.
Good point. And I appreciate your compassion for the emotional cost as well. That was well said. Thank you. So, as we wrap up today, when you look at a case early on, what are the factors that help you determine whether it's likely to settle or move all the way towards trial?
It depends on the quality of evidence. And I say that not from the plaintiff's perspective. I say it from the attorney of the plaintiff's perspective. The plaintiff always believes that their case is exceptional. They're the ones who have been victimized in their mind. They're the ones who have lived through this experience that I have not lived through. And so I need to take what they tell me and then go find corroborating evidence, be it a person who witnessed it, be it a text message, be it a video, something that corroborates what they say, and be able to take that and demonstrate the same level of pain that the plaintiff, my client, is expressing to me through something other than the plaintiff. That is hard to come by. I mean, we have video phones now that we didn't have 20, 30 years ago. But now if you don't have the video evidence, juries demand it. So you're sort of damned if you do and damned if you don't. If you don't have the evidence, why don't you have the evidence? If you do have the evidence, is it legitimate? Have you, with AI, manipulated it? So it's complicated, and it's very time consuming from the attorney's perspective to try to organize this in a way that proves the plaintiff's case at the same level of emotion and intensity that they're able to express it. Remember, the plaintiff saying it is definitely necessary, but the ability to prove it through corroborating evidence is critical. So the less corroborating evidence you have, the less enticing that case is as an attorney to take on their behalf because I'm fronting the expenses.
Well, thank you for all of that insight. And to our audience, that is it for today's episode of Legal Insight with Mixon, Carroll, and Frazier. If you'd like to learn more about James Carroll and his team at Mixon, Carroll, and Frazier, visit mixoncarroll.com. You can find more resources there and stay up to date with future episodes. Thanks for listening, and remember to subscribe, share, and leave a review if you found today's episode especially helpful. Thank you, James.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.